So, very good evening, all the participants. Today, we will be studying section 8 and section 9 minimum. And then, if possible, then we can go on to section 10 also. I hope my screen is visible. Is it visible?
Yes, sir.
Section 8. So, what section 8 says? Section 8 says that an operational creditor. Now, who is an operational creditor? ऑपरेशनल क्रेडिटर
Other,
कौन होता है?
whether they're FC,
हैं?
No,
other than
sir.
FC.
Giving goods and services or government
Right.
agencies of
Suppose income tax department has got dues of 2 crores. Whether income tax department can file a petition under IBC?
yes, sir.
Yes. So anybody who has supplied goods or rendered services or who is an employee or a government department, all are covered under operational creditors. Insolvency resolution by operational creditor. An operational creditor may, on the occurrence of a default, deliver a demand notice of unpaid operational debt. So first of all, they have to give a demand notice of an unpaid operational debt or copy of an invoice demanding payment of the amount involved in the default to the corporate debtor in such form and manner as may be prescribed. So first of all, they have to deliver a demand notice. They cannot straight away file a petition under IBC. So first of all, they will give a demand notice, and then the corporate debtor shall, within a period of 10 days. So corporate debtor has got a time period of 10 days to revert, right? Of the receipt of demand notice or copy of invoice, bring to the notice of the operational creditor existence of a dispute, if any. So the corporate debtor may say that okay, there is a dispute, right? Or record of pendency of the suit or arbitration proceedings. So the CD may say that okay, one suit is already pending or arbitration proceeding is already pending. But that should have been filed before the receipt of such notice or invoice in relation to such dispute. Suppose a corporate debtor gets a demand notice, right? After the receipt of demand notice, he cannot file a suit, right? So the point here is that it should not be an afterthought. It should not be merely to avoid this IBC process, right? So he will say that a dispute exists, if any, or record of pendency of the suit or arbitration proceedings filed before the receipt of such notice or invoice in relation to such dispute. Second is payment of the unpaid operational debt. So the CD may say that you are demanding payment, but I have already paid the amount to you, and this is a proof. So proof we will send by sending an attested copy of the record of electronic transfer of the unpaid amount from the bank account of the CD, or by sending an attested copy of record that the operational creditor has encashed a check issued by the corporate debtor, right? An explanation for the purpose of this section: a demand notice means a notice served by an operational creditor to the corporate debtor demanding payment of the operational debt in respect of which default has occurred. So these are the conditions before filing an application under section 8. Now let us see this rule 5 also. So what rule 5 says? Let us see rule 5 also. So this is rule number 5. So rule number 5, what it says? It says demand notice. So an operational creditor shall deliver to the corporate debtor the following documents, namely a demand notice in form number 3 or a copy of an invoice attached with the notice in form number 4, right? The demand notice or the copy of the invoice demanding payment referred to in subsection 2 of section 8 may be delivered to the corporate debtor. So where this demand notice or invoice has to be delivered? At the registered office by hand, registered post or speed post with acknowledgement due, or by electronic mail service to a whole-time director or designated partner in case of LLP or KMP if any of the corporate debtor, right? So it could be served at anywhere, at any of these places, right? and a copy of the demand notice or invoice demanding payment served under this rule by an operational creditor shall also be filed with an information utility if any. Right? Now, let us read this rule 6 also, application by operational creditor. Now, suppose demand notice or invoice demanding payment has been delivered properly and the CD does not revert. CD does not attach proof of payment or he does not point out any dispute. Then the operational creditor shall file an application. The application by operational creditor shall be filed in form number 5, accompanied with documents and records required therein and as specified in the CIRP regulations. So, what are the documents? They are given in regulations. And the applicant under sub-rule 1 shall serve a copy of the application to the registered office of the corporate data and to the board by registered post or speed post or by hand or by electronic means before filing with the adjudicating authority. So this form, copy of this form 5 has to be delivered to the registered office of the corporate data and to the board by registered post or speed post or by hand or by electronic means before filing with the adjudicating authority. So now let us see section 8. So what section 8 says? Section 8 now we have completed. Now let us move to section 9. Just a minute. Now section 9. What section 9 says? Section 9 says application for initiation of corporate insolvency resolution process by operational creditor. So it says after the expiry of the period of 10 days. So 10 days the operational creditor has issued a demand notice or copy of invoice. 10 days have expired. Then on the 11th day, after the expiry of the period of 10 days, from the date of delivery of the notice or invoice demanding payment, under subsection or section 8, if the OC does not receive payment, now he neither receives payment nor any notice of dispute. So if CD points out that there is a dispute, then also the OC cannot file the petition. The operational creditor may file an application before the adjudicating authority for initiating a corporate insolvency resolution process. Right? So what are the conditions? He should not have received payment. He should not have received notice of dispute. Now this application under subsection 1 shall be filed in such form and manner and accompanied with such fees as may be prescribed. So we have to again go to the rules for this purpose. So let us see rule number 6, 8 and 10. What rule 6 says? That application has to be in form number 5. Right? 8 is regarding withdrawal of the application. So application once filed by the OC can be withdrawn also on a request made by the applicant before its admission. And then filing of application and filing fees. So this is given in the schedule and schedule says fees for filing an application by operational creditor is 2000, right? So in this case what it says, application made under subsection 2 is incomplete or there has been payment of the unpaid operational debt, right? Right. So application shall be filed in such form and manner as may be prescribed. So we have seen rule 6, 8 and 10. The operational creditor shall, along with the application, furnish a copy of the invoice demanding payment or demand notice delivered by the operational creditor to the CD, right? Affidavit to the effect. Because on the one side, CD has to say that there is no dispute, and then affidavit also has to be given by the OC that there is no notice given by the corporate debtor relating to a dispute of the unpaid operational debt, right? Then a copy of the certificate from financial institution maintaining accounts of the operational creditor confirming that there is no payment of an unpaid operational debt by the corporate debtor if available. So a certificate from the bank may also be obtained if the banker is willing to give, otherwise it's not required, right? The word if available were inserted later because there was genuine problem before the OCs that bankers were refusing to issue this certificate. Then copy of any record with the information utility confirming that there is no payment of an unpaid operational debt by the corporate debtor if available, right? Any other proof confirming that there is no payment of an unpaid operational debt by the corporate debtor or such other information as may be prescribed. So these are the documents to be attached. Then an operational creditor initiating a CIRP process under this section may propose a resolution professional to act as IRP. So it is optional for the OC to propose the name of an insolvency professional, right? The adjudicating authority shall within 14 days of the receipt of the application under subsection 2 by an order. So the word here used is shall, whereas in section 5, in section 7, they have used the word may, right? Now let me again take you to section 7. So section 7 says, the adjudicating authority shall so it says, section 5A says it may by order reject such application. And it says it may by order admit such application. So the wording used in section 7(5) is may. Whereas in section 9, they are using the word the adjudicating authority shall. Right? The adjudicating authority shall within 14 days of the receipt of the application under subsection 2 by an order admit the application and communicate such decision to the operational creditor and the corporate debtor. If the application made under subsection 2 is complete, there is no payment of the unpaid operational debt, the invoice or notice for payment of the corporate debt has been delivered by the operational creditor, no notice of dispute has been received by the operational creditor, or there is no record of dispute in the information utility, and there is no disciplinary proceeding pending against any resolution professional. So these are the conditions, right? So if all these conditions are met, then the adjudicating authority shall admit the application. Otherwise, it will reject the application and communicate such decision to the operational creditor and the corporate debtor. If the application is incomplete, there has been payment of the unpaid operational debt, the creditor has not delivered the invoice or notice for demand for payment to the corporate debtor, notice of dispute has been received by the operational creditor, or there is a record of dispute in an information utility, or any disciplinary proceeding is pending against any proposed RP. Provided that the adjudicating authority shall give an opportunity of being heard, shall give a notice to the applicant to rectify the defect within 7 days, right? And the CIRP process shall commence from the date of admission of the application under subsection 5 of this section. So there is a difference between the admission of an application under section 7 and section 9. In section 7, the conditions are limited. What are the conditions in section 7? Default has occurred, application is complete, and there is no disciplinary proceeding pending against the proposed IR. Right? So these are the only conditions. But in section 9 application, conditions are more. Application has to be complete. There is no payment of the unpaid operational debt, right? Creditor has delivered the notice. No notice of dispute has been received and no disciplinary proceeding is pending. Only then application shall be admitted. Otherwise, the application shall be rejected. But 7 days time shall be given to rectify the defect in the application in both the cases, in section 7 application as well as section 9 application. Now, we can move to section 10. What section 10 says? Section 10 says initiation of corporate insolvency resolution process by the corporate applicant. So as we saw, three types of applicants can file the application. Application can be filed by financial creditor under section 7, which could be by an individual financial creditor or by jointly, some of the financial creditors jointly, or by a class of creditors or home buyers. But in section 9, whether joint application can be filed? The answer is no. In section 9, each operational creditor has to individually file the application and there can be no clubbing. Suppose there are 4 operational creditors, each having a default of 25 lakhs. So can they join hands? The answer is no. But in case of financial creditors, joint application is permitted. Now section 10. Section 10 says initiation of corporate insolvency resolution process by corporate applicant. So where a corporate debtor has committed a default, a corporate applicant thereof. And we have seen the definition of corporate applicant also. What is the difference between the corporate debtor and corporate applicant? So the term corporate applicant includes a corporate debtor also, right? The term corporate applicant is much wider than the term corporate debtor. And corporate applicant includes not only the corporate debtor but CEO, CFO, etc. etc. The definition given in section 5, subsection 5. So where a corporate debt, but in all these cases, section 7 application, section 9 application and section 10, there has to be a default. If there is no default, then application cannot be filed. Right? Where a corporate debtor has committed default, a corporate applicant thereof may file an application for initiating CIRP with the adjudicating authority. The application under subsection 1 shall be filed in such form containing such particulars and in such manner and accompanied with such fees as may be prescribed. Right? So we have to go again to rule number 7, 8 and 10. So what is the fees? Fees is 25,000 rupees. What is the form number? Form number 6. Right? The corporate
Okay.
applicant shall along with the application furnish the information relating to its books of accounts, because here the corporate debtor has committed a default and corporate applicant is filing on behalf of the corporate debtor. So they will furnish along with the application the information relating to its books of accounts and such other documents for such period as may be specified. The information relating to the resolution professional proposed to be appointed as IRP and the special resolution passed by shareholders of the corporate debtor or the resolution passed by at least 3/4 of the total number of partners of the corporate debtor in case of LLP. So in case of LLP, the resolution has to be passed by at least 3/4 of the total number of partners. So it is not designated partners here, it is partners. Or in case of a company, it has to be a special resolution. Right, as the case may be, approving the filing of the application, and the adjudicating authority shall within a period of 14 days of the receipt of the application admit the application if it is complete and no disciplinary proceeding is pending, or reject the application if it is incomplete or disciplinary proceeding is pending. Right, then they will give notice to rectify the defect within 7 days. Now let us see the list of documents which are to be attached along with an application under section 10. Right? Let us see the. So the list of documents to be attached is given in form number 6. So if we see the annexes to form number 6, so then they outline the number of the records to be furnished. Let us see form number 6. This is form number 6, application by corporate applicant. Now let us see what are the records to be included. What are the records to be attached? Now, if the corporate applicant is filing an application, then there must have been a default. Default is necessary. You know, in case the default is towards a financial debt, so in case of financial debt, a record of default obtained through the information utility. How the information utility gives the information of record? In form number D, or all documents listed in serial number 8 of part 3 of this application. Now see what is given in serial number 8 of part 3. Part 3, serial number 8. List of documents attached to the application in order to prove the existence of financial operational debt and the amount in default. It could be check bouncing case, it could be anything. Second is, in case of operational debt, copy of invoice, demand notice served by an operational creditor, and record of default obtained through the information utility, or all documents listed in serial number 8. Then written communication by the proposed IRP as set out in form 2. So here consent of IRP also has to be taken. Then copy of relevant books of account of the corporate debtor evidencing the default to creditors. This also has to be attached. Then copies of audited financial statements of the corporate debtor for the last 2 financial years and the provisional financial statements for the current financial year made up to a date not earlier than 14 days from the date of the application. This is also important, right? For the last 2 financial years and the provisional financial statements for the current financial year made up to a date not earlier than 14 days from the date of filing of the application. Now, suppose we are in financial year 25-26. Say today is 29th of January 2026. And suppose today we are going to file the application, then the accounts must have been made up to a date not earlier than 14 days from the date of the application, right? So accounts have to be made up to 15th of January, right? A statement of affairs made up to a date not earlier than 14 days from the date of application, including the following documents. Statement of affairs. List of the corporate debtors' assets and liabilities divided into such categories as are appropriate for easy identification with estimated values assigned to each category. In the case of any property on which a claim against the corporate debtor is wholly or partly secured, particulars of the claim and its amount and of how and when the security was created. The names and addresses of the financial creditors and operational creditors of the corporate debtor with the amounts due to each of them. So all these documents are to be attached with form number 5. Particulars of any debt owed by or to the corporate debtor or to or by persons connected with it. Whether any, and if so, what guarantees have been given in relation to the debts of the corporate debtor by other persons, specifying which, if any, of the guarantors is a related party to the corporate debtor and the corporate applicant. And the names and addresses of the members and partners of the corporate debtor, as the case may be, with details of their respective shareholdings. Then a copy of the relevant extract of any constitutional document or shareholders agreement that records the authority of the corporate applicant to make this application, where the corporate applicant is a member or partner of the corporate debtor. Then relevant extract of an employment agreement, constitutional document or filing made to the registrar of companies confirming the authority of the corporate applicant to make this application, where the corporate applicant is an individual in charge of managing the operations and resources or has control and supervision. Then affidavit and proof that the specified application fees has been paid, proof that the copy of the application has been served to the board. So all these documents are to be attached, right? So this is the section 10 application. Section 10 application में maximum documents लगाने हैं आप, ठीक है? Now section 10A. 10A क्या बोलता है? Section 10A talks of suspension of the initiation. But during COVID period, so this process of filing an application under section 7, 9 or 10 was suspended for a brief period. So it says, notwithstanding anything contained in section 7, 9 and 10, no application for initiation, because application can be filed for initiation only, right? So no application for initiation of CIRP shall be filed for any default arising on or after 25th March. This 25th March was the lockdown period. For a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this behalf. Ultimately, it was extended up to 1 year. So 6 months, then 3 months, and then again 3 months. Provided that no application shall ever be filed for initiation of corporate insolvency resolution process of a corporate debtor for the said default occurring during the said period. So if any default has occurred during this pandemic period, then no application shall ever be filed. Explanation: for the removal of doubts, it is hereby clarified that the provisions of this section shall not apply to any default committed under the said sections before 25th March. So there could be a case where the default occurred before 25th March. Then application can be filed, right? Then section 11. Section 11 talks of persons who are not entitled to make the application. So this basically covers the provisions where already one process is going on against the corporate debtor. The following persons shall not be entitled to make an application to initiate CIRP process under this chapter, namely corporate debtor undergoing CIRP or PPIRP. So if a person is already undergoing CIRP process, right? Suppose one application has already been admitted, then second application cannot be admitted, because then the people will be filing claims pursuant to that process. Second, financial creditor or an operational creditor of a corporate debtor undergoing a prepackaged insolvency resolution process. So prepackaged insolvency resolution process we will read in detail later. But here briefly we can understand that in case of prepackaged insolvency resolution process, which is restricted to corporate MSMEs only, the corporate debtor is allowed to make an application for a default of 10 lakhs or more, right? So in case an application has been admitted under PPIRP, or if a CD is undergoing PPIRP process, then financial creditor or operational creditor cannot file this application. The corporate debtor having completed CIRP process 12 months preceding the date of making of the application. So let us understand it this way, that if a person is already admitted into ICU, then nobody can be allowed to disturb him. Here this 12 months is the cooling period. Suppose, so 12 months have to elapse before making another application. Suppose a default occurred, CIRP was admitted, so he was over from that process. So it says if the CIRP is completed, then also you have to wait for 12 months, because you have to allow for the things to get stabilized. Then a corporate debtor in respect of whom a resolution plan has been approved 12 months preceding the date of making of the application. So this 12 months is basically the cooling period. A corporate debtor or financial creditor who has violated any terms of the resolution plan which was approved 12 months before the date of making of an application. A corporate debtor in respect of whom a liquidation order has been passed. So all these situations which are given in section 11, so they are talking of where CIRP is already going on, PPIRP is going on, 12 months have not elapsed, etc., etc. So they want to get the things stabilized before another application can be made. This is the gist, right? Then 11A. 11A talks of situations where basically this section you will be able to understand better when you read this pre-pack insolvency resolution process. But just to cut it short, pre-pack insolvency resolution process is allowed only in limited cases. It is allowed only for corporate MSMEs, whereby the corporate debtor itself can make the application. And pre-pack, as the name implies, it itself signifies that something pre-prepared is being offered to the uh, claimants or creditors. It is a process which is beneficial to the corporate debtor because it allows the corporate debtor to retain control. Whereas in other cases like section 7 or section 9 or section 10 application, the control is no longer with the existing management and control shifts to the insolvency resolution professional, right? So here section 11 talks of cases where section 7, 9 or 10 application is pending and then application is made under pre-pack process also, because this pre-pack process was introduced in the year 2021. So it says how the treatment will be done. So basically the intent of section 11 is, we'll again come back to this section after reading pre-pack insolvency resolution process, which is given in section 54. So here what it says basically that if pre-pack application is made first, then it will be given priority. If section 7, 9 or 10 application has already been filed and then pre-pack application is filed, so within 14 days, so then also pre-pack will be given priority. But if section 7, 9 or 10 application has been filed earlier and thereafter, after 14 days, pre-pack process application is filed, then section 7, 9 or 10 application will get precedence. This is the meaning, right? Now section 12. Section 12 says time limit for, because it's a time bound process. We have already read in the preamble also that it's a time bound process. So it says subject to subsection 2, the CIRP process shall be completed within a period of 180 days from the date of admission of the application to initiate such process. So there is a time bound process of 180 days. And suppose it is not complete within 180 days, then the resolution professional shall file an application to the adjudicating authority to extend the period of CIRP process beyond 180 days if instructed to do so by a resolution passed at a meeting of the committee of creditors by a vote of 66% of the voting shares. So they have to pass a resolution at a meeting of the committee of creditors, and then the RP shall file an application to the adjudicating authority to extend the period, right? On receipt of an application under subsection 2, if the adjudicating authority is satisfied that the subject matter of the case is such that CIRP cannot be completed within 180 days, it may by order extend the duration of such process beyond 180 days by such further period as it thinks fit, but not exceeding 90 days. So normal period is 180 days. If it is not complete within 180 days, then the committee of creditors shall pass a resolution. Voting percentage is 66%. And then RP shall file the application. And adjudicating authority is having discretion to extend the period but not exceeding 90 days. And provided that any extension of the period of CIRP under this section shall not be granted more than once. So only one time extension of 90 days shall be granted. Now, this 180 plus 90 days was also not sufficient and CIRPs were not completed. Then what the adjudicating authority was doing? Adjudicating authority was excluding certain time period. So they were taking an argument that okay, such and such time was lost in litigation and so many other things. So let us exclude that period to bring it back to 270 days. But because it became the norm, so another amendment was brought and it says that the CIRP process shall mandatorily be completed within a period of 330 days. So 180, 270 and now 330. But it says it shall mandatorily be completed, right? Including any extension and the time taken in legal proceedings. But the word mandatorily I have highlighted because this word mandatorily also has to be read ordinarily. So naturally, every endeavor should be made to completed within 330 days, but there could be situations where CIRP may not be completed even within 330 days, right? And because this amendment came at a later date, so they say that if any CIRP is pending, then another 90 days shall be granted. Now section 12A. Section 12A was also introduced at a later date, because when IBC came initially, there was no provision for withdrawal of application. So section 12A says that once an application has been admitted under section 9 or 7, 9 or 10, then there is a provision for withdrawal. So it says the adjudicating authority may allow the withdrawal of application admitted under section 7 or 9 or 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors in such manner as may be specified. So it says it has to be done with the approval of the committee of creditors. And then there is regulation 30A also. So regulation 30A says what are the conditions on which this withdrawal of application may be admitted. So they particularly point out to submission of a bank guarantee to fund the cost incurred till the date of filing of the application, about which we will read in detail later, right? Now section 13 says declaration of moratorium and public announcement. The adjudicating authority, after admission of the application under section 7 or 9 or 10, shall by an order declare a moratorium. So it is something similar to a person admitted to a hospital. So if a person is admitted into ICU, then nobody is allowed to disturb him, right? So similar is the situation here. Once an application has been admitted, then a moratorium shall be declared, right? Cause a public announcement shall be made, and claims shall be invited, and appoint an IRP in the manner as laid down in section 16. And the public announcement shall be made immediately after the appointment of the IRP. So these are the things to be done on admission of an application. Section 14, a very important section. It talks of the moratorium. So basically, moratorium implies that there will be no disturbance to the company, to the corporate data which is undergoing CIRP. Suppose somebody is admitted to the hospital, then the doctors will not allow the patient to be disturbed. So this is something similar, that the company, the corporate data which is undergoing CIRP process, so certain actions cannot be taken during this period. Period we have already seen, 180 days, one time extension of 90 days, 330 days, right? So what it says, subject to the provisions of subsection 2 and 3, on the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following. So all these activities shall be prohibited. What? Institution of suits. So no new suits can be filed, or continuation of pending suits or proceedings. If there are some suits which are pending or proceedings which are pending, then they shall also be prohibited against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration, panel or other authority. Suppose a decree has been granted against the CD, whether it can be executed, the answer is no. So during this period, which is given in section 12, so even execution of decree is also barred, right? Then transferring, encumbering, alienating or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest therein. Now suppose the CD wants to transfer its assets. Can it do so? The answer is no. So during this period, there can be no transfer, there can be no encumbrance, mean no creation of any charge, alienation or disposing of by the CD any of its assets or any legal right or beneficial interest therein. Any action to foreclose, recover or enforce any security interest created by the corporate debtor in respect of its property, including any action under SURFACE, right? So no foreclosure can be done, no recovery or enforcement of any security interest can be done, including action under SURFACE. So all these actions are barred during this time period, which is given in section 12. Recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor. So suppose the corporate debtor is being run from rented premises. So whether the landlord can ask the CD to vacate, the answer is no. Right? So recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor also cannot be done. So all these activities cannot be done during this period of 180 plus 90 or 330 days. Right? But suppose some quota, license, permit, etc. is there. So whether it can be terminated, whether it can be suspended, the answer is no. Because the corporate debtor is expected to be run as a going concern. The idea is to run the company and try to find out a new entrepreneur who is willing to take over that company. That is the basic idea behind this IBC. It is not a recovery legislation. It is not to benefit the creditors. It is to benefit the corporate debtor. Basically, it's a welfare legislation. They want to uh, bring that company which is into financial insolvency, which is into financial trouble, out from that trouble, right? So basically, they say that if any registration, quota, license is granted, so let them pay the current dues, and till the time there is no default in payment of current dues, then this license, permit, registration, quota cannot be cancelled. Let us take the case of a say telecom service provider. Now this telecom service provider is not able to pay the dues, right? Now the question is whether that spectrum license can be cancelled. The answer is no. So long as the corporate debtor is paying the current dues, that spectrum license cannot be cancelled or removed. Why? Because the idea is to keep it as a going concern. And who will come to buy the company if there is no license? So license is the crux of that company, right? Second is supply of essential goods or services to the corporate debtor as may be specified shall not be terminated or suspended or interrupted during the moratorium period. Now what are these essential goods or services? These essential goods or services are electricity, water, telecommunication, information, technology services. So, suppose a company is into CIRP. Whether electricity connection can be disconnected? The answer is no. Whether water supply could be disconnected? The answer is no. Whether telecommunication services, say telephone, or information technology services, say Wi-Fi, etc. So, all these services cannot be terminated. These come under the essential services because unless these services are maintained, it cannot run as a going concern. So even if payment is not made, then also these services cannot be terminated. This is the idea. Okay. Now third, there are certain goods or services which are considered critical. So there are three types of goods or services. Number one, say license, permit, quota, etc. So for that, the law says that as long as you are paying the current dues, supply cannot be terminated. Second, regarding essential goods or services, supply cannot be terminated or suspended. Right? It doesn't say anything about whether current dues have to be paid or not. So indirectly it means that the electricity connection cannot be disconnected even if the city doesn't pay anything during this period. Right? Because it has to be kept as a going concern. Third is, suppose some goods or services are critical, right? To protect and preserve the value of the corporate debtor and manage the operations of such corporate debtor as a going concern. So a company is into the business of running a turbine unit, right? And coal is an essential input for that. So then it says, as long as the current dues are being cleared, so supply cannot be interrupted. Why? Because otherwise it will affect the going concern status. And once going concern status is affected, then no buyer will come. The provisions of subsection 7 shall not apply to such transactions as may be notified by the central government or a surety in a contract of guarantee to a corporate debtor. So all these restrictions regarding institution of suits, right, filing of new suits, all these restrictions are applying in relation to the corporate debtor only. But suppose there is a surety, there is a guarantor who has given a guarantee. So whether these restrictions can apply to that guarantor also, the answer is no. So if a company has taken a loan, then you cannot file an action against the company. But whether you can file an action against the guarantor, the answer is yes. Right? Because guarantor is a separate entity. The order of moratorium shall have effect from the date of such order till the completion of the CIRP process. Right? Provided that where at any time during the CIRP process, if the adjudicating authority approves the resolution plan or passes an order for liquidation, the moratorium shall cease to effect from the date of such approval or liquidation order as the case may be. So section 14 basically prohibits certain actions during the CIRP period. What is the idea? The intent is to keep it as a going concern. Suppose you disconnect the electricity supply, then it will not be able to run as a going concern, right? Similarly, if you revoke the license, if you revoke the permit quota, then also there will be problem. So it says, so long as it is paying the current use, you cannot interrupt the supply. You cannot terminate the quota, license or permit. Now section 15. Section 15 talks about the public announcement of CIRP process. The public announcement of the corporate insolvency resolution process shall contain the following information: name and address of the CD, name of the authority with which the corporate debtor is incorporated or registered, say MCA, last date for submission of claims as may be specified, details of the IRP, who shall be vested with the management, because here the management will be taken over by the IRP, right? The powers of the board shall stand suspended and be responsible for receiving claims, then penalties for false or misleading claims, and the date on which the CIRP process shall close, which shall be 180th day, because initially the timelines have to be maintained as per 180 days. So from the day one, you cannot presume that there will be extension. So first of all, you have to say plan the process in such a way that it is completed by 180th day. The public announcement under this section shall be made in such manner as may be specified. And there is a regulation 6 for this. Let us see regulation 6 also. So regulation 6 says that an insolvency professional shall make a public announcement immediately on his appointment as an IRP. And immediately means not later than 3 days from the date of his appointment. Public announcement shall be in Form A of the Schedule 1, and it has to be published in one English and one regional language newspaper with wide circulation at the location of the registered office and principal office, if any, of the corporate debtor, and any other location where in the opinion of the IRP the corporate debtor conducts material business operations. Now let us see what is the idea behind this public announcement. The idea behind this public announcement is to make people aware that this company is into insolvency. And now people will be able to file their claims, right, on the website, if any, of the corporate debtor. So wherever any material operations are there, suppose a company is running 4 plants in 4 different states. So this public announcement will be made in 4 different states in one English and one regional language newspaper. On the website, if any, of the CD, and on the website, if any, designated by the board for the purpose. It shall state where claim forms can be downloaded or obtained from, as the case may be. Offer choice of 3 insolvency professionals identified under Regulation 4A to act as authorized representative of creditors in each class. Because in case of class of creditors, an authorized representative has to be appointed. Now, how this will be appointed? It is given in regulation number 4A. Regulation 4A says that the IRP shall identify 3 insolvency professionals and their names will be given in the public notice. Out of them, one has to be selected. Provide the last date for submission of proofs of claim, which shall be 14 days from the date of appointment of the IRP, and the applicant shall bear the expenses of the public announcement, which may be reimbursed by the committee to the extent it ratifies them. So this is provision regarding public announcement. Now let us see Form A also. What is Form A? This is Form A. Form of public announcement. Name of the CD, date of incorporation, authority under which it is incorporated or registered, say MCA, SIN number, LLP number, address of the registered office and principal office, insolvency commencement date. So this is the date of the order. Estimated date of closure. So this will be 0 plus 180. Name and registration number of the insolvency professional acting as IRP. Address and email of the IRP as registered with the board. Address and email to be used for correspondence. Last date for submission of claims, which is 14 days from the insolvency commencement date. Then class of creditors, if any, right? So name of the classes, then name of the insolvency professionals identified to act as AR. So 3 names will be given. Then relevant forms and details of the authorized representatives are available at this web link or physical address, right? Then notice is hereby given that the NCLT has ordered the commencement of CIRP on this date, right? The creditors of the CD are hereby called upon to submit their claims with proof on or before, insert the date falling 14 days from the appointment of the IRP to the IRP at the address mentioned against entry number 10. Financial creditors shall submit their claim with proof by electronic means only, right? All other creditors may submit the claims with proof in person, by post or by electronic means, right? A financial creditor belonging to a class as listed against entry number 12 shall indicate its choice of authorized representative from among the 3 insolvency professionals listed against entry number 13. Then submission of false or misleading proofs of claim shall attract penalties and name address of the signature of the IRP. So this is what is given in the public announcement. ये है public announcement का form. तो सेक्शन 15 अपना कंप्लीट हो गया. नाउ सेक्शन 16. सेक्शन 16 क्या बोलता है? दिस इज सेक्शन 16. Appointment and tenure of the IRP. The adjudicating authority shall appoint an IRP on the insolvency commencement date, right? So in an application under section 7, which is given by a financial creditor, or section 10, which is filed by the corporate applicant, the name of the IRP has to be given. Necessary, it is mandatory. So in such cases, that IRP shall be appointed if no disciplinary proceedings are pending against him, right? But in case of an application by operational creditor, he may or may not give the name of the IRP. So then, if no proposal for IRP is made, adjudicating authority shall make a reference to the board for recommendation of an insolvency professional. Now, board is sharing a panel with the adjudicating authority, which is the NCLT, and out of that panel, one insolvency professional is appointed in case the name of the IRP has not been given by the operational creditor. Okay? And suppose OC has also given the name, which he may give. So then we will see that there are no disciplinary proceedings pending, right? And wherever a reference is made to the board, board shall revert within 10 days. And the terms of the IRP shall continue till the date of appointment of the resolution master. So this is regarding the appointment and tenure of the IRP. Now let us see regulation number 3 also. What regulation 3 says? Regulation 3 talks of the eligibility for resolution professional who can be appointed. Because an insolvency professional is supposed to be an independent person. So he should not be having any conflict of interest with the corporate debtor, right? An insolvency professional shall be eligible to be appointed as an IRP or RP as the case may be for a CIRP of a corporate debtor if he and all partners and directors of the IPE of which he is a partner or director are independent of the corporate debtor. So independence with the corporate debtor has to be maintained, not only of that person but all the directors and partners of the IPE of which is a partner or director, right? Suppose there is an IPE, right? And in IPE, 10 partners are there. So, not only the person who is proposed to be appointed, but the other partners or directors also, they should also be independent. And how this independence has to be ascertained? Number one, if he is eligible to be appointed as an independent director on the board of the CD, where the corporate debtor is a company. And those qualifications, those conditions are given in section 149 of the Companies Act. He should not be a related party of the corporate debtor. The concept of related party we have seen in section 5 subsection 24. Or is not an employee or proprietor or partner of a firm of auditors or secretarial auditors in practice or cost auditors of the corporate debtor. अगर कोई फर्म ऑफ ऑडिटर्स है, सेक्रेटरियल ऑडिटर्स है इन प्रैक्टिस और कॉस्ट ऑडिटर्स, तो उसका एम्प्लॉय नहीं होना चाहिए, प्रोपराइटर नहीं होना चाहिए, पार्टनर नहीं होना चाहिए, ठीक है. ऑफ ए लीगल और कंसल्टिंग फर्म, सपोज देयर इज ए लीगल और कंसल्टिंग फर्म, ठीक है, एंड दैट लीगल और कंसल्टिंग फर्म इज हैविंग transactions with the corporate debtor, then what is the percentage? Percentage is 5% or more of the gross turnover of such firm. Suppose there is a legal or consulting firm that has got a turnover of say 100 crores. Now, if that consulting firm is having say 10 crores transactions with the CD, that means it is 5% or more, right? So in that case, he will be considered to be not independent. It has to be less than 5%, right? And what has to be seen? The turnover of that consulting or legal firm and what is the amount, what is the transaction which it is having with the CD, right? Suppose the legal or consulting firm has got a turnover of 100 crores, then 5 crores or more if they are getting from that CD, then they cannot in any of the in the last 3 financial years. It has to be seen year wise, right? So we don't have to club all these 3 to calculate this 5%. It has to be calculated on year to year basis. So in all these cases, he will not be considered to be independent, right? Now let us see section 16. सेक्शन 16 पढ़ते हैं हम. तो सेक्शन 16 क्या बोलता है? सेक्शन 16 बोलता है अपॉइंटमेंट एंड टेन्योर ऑफ द IRP. The adjudicating authority shall appoint an IRP on the insolvency commencement date, right? In case of section 7 or 10, name of the IRP has to be recommended by the applicant. Then if no disciplinary proceedings are pending, that person will be appointed. Otherwise, they will ask the information from the board. Similarly, in case of OC, He may or may not give the name. In case he doesn't give the name, then the adjudicating authority shall make a reference to the board and board shall revert within 10 days. Right? And if the name has been given by the OC, then they will ensure that there is no disciplinary proceeding. So this is regarding appointment and tenure of IRP. Now section 17. What section 17 says? Management of affairs of the corporate debtor by the IRP. So from the date of appointment of the IRP, the management of the affairs of the corporate debtor shall vest in the IRP. Right? So now who will be responsible for managing the affairs? The IRP. The powers of the board of the directors or the partners of the corporate debtor, as the case may be, shall stand suspended. So board as such is not being suspended. Powers of the board of directors or partners of the CD are suspended and be exercised by the IRP. So there is a difference between suspension of the board and suspension of powers of the board. They continue to be directors, but they will become powerless. The officers and managers of the corporate debtor shall report to the IRP. So everybody, the officers, employees, managers of the corporate debtor, they shall report to the IRP and provide access to such documents and records of the corporate debtor as may be required by the IRP. The financial institutions, the bankers, to whom they will report? They will also report to the IRP. The financial institutions maintaining accounts of the corporate debtor shall act on the instructions of the IRP in relation to such accounts and furnish all information relating to the corporate debtor available with them to the IRP. Right? So everybody is reporting now to the IRP instead of the board of directors. Okay? The IRP vested with the management of the corporate debtor shall act and execute in the name and on behalf of the corporate debtor. Suppose some agreement has to be signed. Now, who will sign that agreement? The IRP and not the board of directors. Okay? He shall act and execute in the name and on behalf of the corporate debtor all deeds, receipts and other documents. So we will say for XYZ Private Limited, Mr. Ramlal IRP. The company continues to exist. Company is not yet dissolved, right? Only the powers of the board have been suspended. So who will execute these documents, deeds, receipts? The IRP on behalf of the corporate debtor. Take such actions in the manner and subject to such restrictions as may be specified by the board. Have the authority to access the electronic records of the corporate debtor from information utility having financial information of the corporate debtor. Have the authority to access the books of account, records and other relevant documents of the corporate debtor available with government authorities, statutory auditors, accountants and such other persons as may be specified. And be responsible for complying with the requirements under any law for the time being in force on behalf of the corporate debtor. So this IRP shall be responsible for complying with the requirements also. Like suppose income tax return is to be filed, then IRP shall be responsible. GST return has to be filed, TDS return has to be filed, right? So for all these things, IRP shall be responsible because now the powers of the board has been suspended. And naturally, then he shall have the authority to access the books of account. So he can seek information from all the authorities, from statutory auditors, accountants, wherever, whosoever are having information, so he can seek, he is the authority to access the information from all such parties in order to carry out his functions as IRP. Section 18 talks of the duties of the IRP. So what are the duties of the IRP? The IRP shall perform the following duties, namely collect all information related to the assets, finances and operations of the corporate debtor for determining the financial position of the corporate debtor. Because first of all, he has to ascertain the information relating to business operations for the previous 2 years. So he has to look back for a period of 2 years. Financial and operational payments for the previous 2 years. So why this 2 years is important? Because that is the look back period. So during this period, if any transaction has been entered into with a related party, Then, and if it is a suspicious transaction, then the IRP shall file an application with the adjudicating authority. Financial and operational payments for the previous 2 years. List of assets and liabilities as on the initiation date. Initiation date means the date of filing. And such other matters as may be specified. Receive and collate all the claims submitted by creditors to him pursuant to the public announcement. So here the question is whether he can reject any claim. The answer is no. He will receive and collate all the claims. He will be maintaining two figures side by side, the claims submitted and claims admitted. Constitute a committee of creditors. So based on the claims received, he will constitute a committee of creditors. Then monitor the assets of the corporate debtor and manage its operations until a resolution professional is appointed by the COC. So these are the duties of the IRP. File information collected with the information utility if necessary, and to take control and custody. So custody and control is also an important aspect. So you shall take control and custody of any asset over which the corporate debtor has ownership rights as recorded in the balance sheet of the corporate debtor. Okay. Assets over which the corporate debtor has ownership rights which may be located in a foreign country. Assets that may or may not be in the possession of the corporate debtor. Intangible assets, tangible assets. So he has to take control and custody over all the assets. Okay. Securities including shares held in any subsidiary of the corporate debtor, financial instruments, insurance policies, assets subject to the determination of ownership by a court or authority. So if there is any dispute, then also if the assets are lying with the corporate debtor, he shall take custody and control. Right? And for the purpose of this section, the term assets shall not include the following, namely assets owned by a third party, right? Held under trust, or assets of any Indian or foreign subsidiary of the corporate debtor, and such other assets as may be notified. So normally he will take control and custody of all the assets. Okay? Section 19, because he has to perform the role of the CEO, CFO, everything, because now the powers of the board stand suspended. So he is all in all. So naturally, all personnel are expected to extend cooperation to the IRP. So the personnel of the corporate debtor, its promoters or any other person associated with the management of the corporate debtor shall extend all assistance and cooperation to the IRP as may be required by him in managing the affairs of the corporate debtor. Where any personnel of the corporate debtor, its promoter or any other person required to assist or cooperate with the IRP does not assist because everybody is expected to cooperate. Now, what happens if somebody doesn't cooperate? He doesn't have any option except to make an application to the adjudicating authority. And the adjudicating authority shall direct such personnel or other person to comply with the instructions of the IRP and to cooperate with him. Now, suppose the IRP feels that okay, he wants to see the information relating to the say land. The CD is being operated from a particular piece of land. Now, the IRP wants to be sure in whose name this land has been registered. So, we'll approach the registrar, and suppose the registrar refuses to give this information. Then the IRP shall file an application to the adjudicating authority, and the adjudicating authority shall instruct the registrar to give the required information. Similarly, if somebody doesn't cooperate, if the control and custody is not granted, then also the adjudicating authority may ask the police authorities to let the IRP take over that company, the custody and control. Okay? Even help of police authorities may be sought. Now, Section 20. Section 20 talks of management of operations of the corporate debtor as a going concern. So, the IRP shall make every endeavor to protect and preserve the value of the property of the corporate debtor and manage the operations of the corporate debtor as a going concern. So during CIRP period, the CD has to be managed as a going concern. And for this purpose, the IRP shall have the authority to appoint accountants, legal or other professionals as may be necessary. So there could be a case where there is already sufficient staff with the corporate data. So if it is necessary, only then he will appoint accountants, legal or other professionals. To enter into contracts on behalf of the corporate data or to amend or modify the contracts or transactions which were entered into before the commencement of the CIRP. Sometimes what the CD does, CD enters into contracts which are unfavorable to the company. The directors enter into some contracts which are unfavorable to the company. They may say enter into a lease agreement with an exorbitant amounts, right, which are not commensurate with the market rates. So in such situation, the IRP may modify or it may amend the contracts, right? To raise interim finance, provided that no security interest shall be created over an encumbered property of the corporate debtor without the prior consent of the creditors whose debt is secured over such encumbered property. So the term interim finance has also been defined. The term interim finance is defined in section 5, subsection 15. So it says interim finance means any financial debt raised by the RP during the insolvency resolution process period. Right? So because the company is into financial trouble, so some financing may be required. So who will raise this interim finance? The IRP. Right? So he shall have the authority to raise interim finance. Now the problem is that whosoever is providing the interim finance, he may also like to have some security. Now, whether the IRP shall be in a position to give that security. So it says, if some security interest has to be created, then the consent of the creditors whose debt is secured over such encumbered property has to be taken. Right? Suppose the CD has already taken a loan and all the assets have been secured. All the loans have been secured to the satisfaction of the creditors. Security interest has been created in favor of the creditors, say bankers. Now, to tide over this financial crisis, the RP is thinking of raising some interim finance. Now, what shall be offered as security? So it says, first of all, you have to take the consent of the creditors whose debt is secured. Provided that no prior consent of the creditor shall be required where the value of such property is not less than the amount equivalent to twice the amount of the debt. Now suppose the CD is having property of 500 crores. The loan amount is 100 crores. So it says you leave twice the amount. So up to 200 crores is sufficient. But because the property cannot be divided into pieces, so that is why the entire property has been offered as security to the existing lenders. So then they say that okay, their debt is only 100 crores. So you keep 200 crores for them, twice the amount of debt, and on the balance 300 crores, because the value of the property is 500 crores. So on the balance 300 crores, you can create a charge. This is the meaning, right? To issue instructions to personnel of the corporate debtor as may be necessary for keeping the corporate debtor as a going concern, and to take all such actions as are necessary to keep the corporate debtor as a going concern. So the idea is basically to keep it as a going concern, right? Now let us see some of the provisions regarding custody and control before we move to section 21. We'll move to section 21 in next class, but let us see some of the provisions regarding custody and control, because recently also there has been a change. So regulation 3A. What regulation 3A says? assistance and cooperation by the personnel of the corporate debtor. The IRP or RP, as the case may be, shall take control and custody as specified under this regulation from the personnel of the corporate debtor. ठीक है, कस्टडी एंड कंट्रोल कैसे लेना, किस किस चीज की कस्टडी एंड कंट्रोल लेना? पहला, रिकॉर्ड्स ऑफ इंफॉर्मेशन रिलेटिंग टू द एसेट्स, फाइनेंसेस एंड ऑपरेशंस ऑफ द कॉर्पोरेट डेटा referred to in clause A of section 18 and such other information required under regulation 36. Assets recorded in the balance sheet of the corporate data or in any other records referred to in clause F of section 18. बैलेंस शीट में इन्वेंट्री दे रखी है तो इन्वेंट्री की कस्टडी एंड कंट्रोल तो देना पड़ेगा ना, ठीक है। अब इस कस्टडी एंड कंट्रोल में लिस्ट कौन बनाएगा एसेट्स की? सीडी बनाएगा, ठीक है। द पर्सनल ऑफ द कॉर्पोरेट डेटा, इट्स प्रोमोटर्स और एनी अदर पर्सन एसोसिएटेड विद द मैनेजमेंट ऑफ द कॉर्पोरेट डेटा शैल प्रोवाइड टू द आईआरपी और आरपी एट द केस में बी ए लिस्ट ऑफ एसेट्स एंड रिकॉर्ड्स, क्योंकि हैंडिंग ओवर तो वही करेगा ना। अभी तक कंट्रोल किसके पास था? सीडी के पास था। नाउ दिस कंट्रोल इज बीइंग हैंडेड ओवर टू द आईआरपी। तो लिस्ट ऑफ एसेट्स एंड रिकॉर्ड्स कौन बनाएगा? जो पर्सनल है कॉर्पोरेट डेटर के, उसके अकाउंटेंट्स, मैनेजर्स वगैरह, ठीक है। while handing over their custody and control, and the IRP or the RP as the case may be, after taking such control and custody, if deemed necessary, identify persons in whose possession these assets and records will be held. क्योंकि वो घर तो ले नहीं जाएगा, कस्टडी एंड कंट्रोल तो ले लिया, ठीक है। मान लीजिए कंप्यूटर्स हैं, कुछ कैश इन हैंड है, कुछ भी चीजें हैं, तो उसमें क्या करेगा? ही विल आइडेंटिफाई द पर्सन्स इन हुज पोजीशन दिस एसेट्स एंड रिकॉर्ड्स विल बी हेल्ड। मान लीजिए कैश इन हैंड है 1,00,000 रुपए, ठीक है। अब कैश इन हैंड अपनी जेब में तो डालेगा नहीं आईआरपी। आईआरपी क्या करेगा? एक जैसे कैशियर है उसकी रिस्पॉन्सिबिलिटी लगा देगा कि भाई यू विल बी रिस्पॉन्सिबल हेंसफोर्थ, ठीक है। अच्छा, अब मान लीजिए कि पब्लिक अनाउंसमेंट हो गया, इंसॉल्वेंसी पिटीशन एडमिट हो गई, बट वो डायरेक्टर्स वहां पर है ही नहीं। तो पहले तो हमने क्या पढ़ा कि भाई डायरेक्टर्स जो है वो लिस्ट बनाएंगे एसेट्स एंड रिकॉर्ड्स की, लेकिन अगर डायरेक्टर है ही नहीं या वो नहीं बनाते तो कौन बनाएगा? तो ये खुद लिस्ट बना लेगा आईआरपी। वेयर एनी एसेट और रिकॉर्ड हैज नॉट बीन हैंडेड ओवर और द लिस्ट हैज नॉट बीन प्रोवाइडेड, ठीक है, अंडर सब रेगुलेशन 2, द आईआरपी और आरपी एट द केस में बी शैल हिमसेल्फ प्रिपेयर ए लिस्ट ऑफ एसेट्स एंड रिकॉर्ड्स। ये खुद ही अपने आप लिस्ट बना लेगा while taking control and custody, ठीक है। तीसरा, अब ये जो लिस्ट बनी, चाहे मैनेजमेंट ने बनाई चाहे आईआरपी ने बनाई, कौन साइन करेगा? जो भी पार्टीज वहां पर प्रेजेंट है कस्टडी एंड कंट्रोल के टाइम पर, ठीक है। और फिर दो कम से कम विटनेसेस बाय एटलीस्ट 2 इंडिविजुअल्स हु हैव विटनेस्ड द एक्ट ऑफ टेकिंग कंट्रोल एंड कस्टडी ऑफ सच एसेट्स एंड रिकॉर्ड्स, ठीक है। द आईआरपी और आरपी एट द केस में भी shall requisition from the personnel of the corporate debtor, its promoters or any other person associated with management of the corporate debtor, information relating to assets, finances and operations, and such information which were required to be maintained by the corporate debtor but have not yet been handed over. इन्वेंट्री में दिया हुआ है कि 5,000 आइटम्स हैं, ठीक है। जो लिस्ट बनाते हैं उसमें शायद 500 आइटम्स हैं, तो ये क्या करेगा? उनको बोलेगा भैया बाकी आइटम कहाँ है, ठीक है। आईआरपी और आरपी में बी शैल रिक्वेजिशन फ्रॉम द पर्सनल ऑफ द कॉर्पोरेट डेटा द एसेट्स विच आर रिकॉर्डेड इन द बैलेंस शीट एंड हुज कस्टडी हैज नॉट बीन हैंडेड ओवर। मान लीजिए बैलेंस शीट में कैश इन हैंड आ रहा है 5,00,000 रुपए, तो भैया वो कैश इन हैंड कहाँ है ना। तो अगर बैलेंस शीट में रिकॉर्डेड है और कस्टडी एंड कंट्रोल नहीं दिया तो ये उनसे मांगेगा पहले। ये मांगना क्यों जरूरी यहां कर दिया? ताकि अगर नहीं मिलेगा तो फिर ये जब एप्लीकेशन देगा एडजुडिकेटिंग अथॉरिटी को, तो एडजुडिकेटिंग अथॉरिटी से पूछेगी भाई तुमने मांगा उससे, ठीक है। अगर इन्वेंट्री वहां दिखा रखी है बुक्स में तो आपको पता चला वहां पर कोई इन्वेंट्री नहीं है, तो क्या आपने इंफॉर्मेशन मांगी है ना। इसीलिए नेक्स्ट रेगुलेशन में क्या बोलता है कि जो 19(2) वाली एप्लीकेशन है इन रिस्पेक्ट ऑफ फेलियर टू प्रोवाइड एनी एसेट और रिकॉर्ड, तो उसमें ये देना पड़ेगा, ही शैल शो द प्रेजेंस ऑफ सच एसेट और रिकॉर्ड इन द नोटिस ऑफ रिक्वेजिशन एंड एब्सेंस ऑफ सच एसेट और रिकॉर्ड इन द लिस्ट ऑफ एसेट्स एंड रिकॉर्ड्स टेकन इन कंट्रोल एंड कस्टडी। तो जब 19(2) की एप्लीकेशन लगाएगा एडजुडिकेटिंग अथॉरिटी को, तो आईआरपी क्या बोलेगा? आईआरपी बोलेगा देखो ऐसा है, मैंने ये इनसे मांगा था और इन्होंने दिया नहीं है, चाहे एसेट्स हो चाहे रिकॉर्ड हो, कुछ भी। ठीक है, तो आज की कथा यहीं समाप्त करते हैं। ये हमारा सेक्शन 20 तक हमने कर लिया। अगर आपका कोई सवाल है इस पर तो वो पूछ सकते हैं, अदरवाइज फिर हम नेक्स्ट क्लास में करेंगे कमेटी ऑफ क्रेडिटर्स। कमेटी ऑफ क्रेडिटर्स को लंबा सेक्शन है तो उसको फिर अलग से कर लेंगे। तो वी हैव कवर्ड अप टू सेक्शन 20 टुडे। बेसिकली समझिए कि प्रोसेस क्या है। ये जो आईबीसी है, इट इज बेसिकली ए प्रोसीजरल लॉ। तो इस प्रोसीजरल लॉ में डिफरेंट प्रोसीजर्स हैव बीन प्रेस्क्राइब्ड। सबसे पहला प्रोसीजर जो हम पढ़ रहे हैं वो है सीआईआरपी। अब सीआईआरपी में क्या होता है? जैसे ही एप्लीकेशन एडमिट होती है, पब्लिक अनाउंसमेंट हो जाएगा, मॉरेटोरियम लग जाएगा। ठीक है, मॉरेटोरियम में क्लेम्स इनवाइट कर लेंगे, क्लेम्स इनवाइट करने के बाद में कस्टडियन कंट्रोल ले लेंगे और इसको एज ए गोइंग कंसर्न बनाने मेंटेन करने की कोशिश करेंगे। ठीक है, जो भी सारा मैनेजमेंट है उसकी पावर सस्पेंड हो जाएगी और सारी कंप्लायंसेस वगैरह के लिए आईआरपी शैल बी रिस्पॉन्सिबल। तो आईआरपी जैसे कंपनी को चलाना चाहे चला सकता है, नए अकाउंटेंट्स मैनेजर्स वगैरह जो भी अगर अपॉइंट करना चाहे तो उनको अपॉइंट कर सकता है। कस्टडियन कंट्रोल लेना है, अगर कस्टडियन कंट्रोल नहीं मिलता या मैनेजमेंट वहां पर है ही नहीं, तो ये अपने आप लिस्ट बना लेगा उसकी। ठीक है, इन द प्रेजेंस ऑफ
सर ये
ओनली टू इंडिपेंडेंट विटनेसेस। यस।
सर one question.
यस।
Whatever the accountant or any professional appointed by IP,
हाँ,
is he required to take the consent of COC for their charges before appointing them or
नहीं देखिए,
anything?
ऐसा
Any?
है, दो चीजें हैं। अपॉइंटमेंट में तो पावर आईआरपी और आरपी की है। नाउ
Mm-hmm.
रिगार्डिंग द रेटिफिकेशन ऑफ कॉस्ट। अब जो कॉस्ट है, कॉस्ट तो कोई भी जो है वो सीओसी के अप्रूवल के बिना नहीं दे सकते।
Mm-hmm. Right.
तो यही प्रोविजन है। अपॉइंटमेंट कर सकता है आईआरपी या आरपी, और कॉस्ट का रेटिफिकेशन जो है वो करेगा सीओसी। इसीलिए
Mm-hmm.
नॉर्मली क्या करते हैं कि जो अपॉइंटमेंट होता है ना उसी टाइम उससे अप्रूवल ले लेते हैं। मान लीजिए अप्रूव कर
Mm-hmm.
दिया, अगर पैसे ही नहीं दिए तो फिर फायदा क्या हुआ? तो ये है।
Yes. Yes.
बट लॉ क्या
Mm-hmm.
कहता है? लॉ ये कहता है अपॉइंट आप कर सकते हो और जो रेटिफिकेशन ऑफ कॉस्ट है वो सीओसी करेगी।
Mm-hmm. Right. और सर ये CIRP का या लिक्विडेशन का अकाउंटिंग ऑडिट का कहीं प्रोविजन है क्या लिखा हुआ?
देखिए
एंटायर
सीआईआरपी में
आईबीसी में?
क्या होता है, सीआईआरपी में तो जैसे कंपनी चल रही थी वैसे ही कंपनी चलती रहेगी। उसकी इनकम टैक्स की
बराबर
रिटर्न, टीडीएस की, जीएसटी की रिटर्न जाती रहेगी क्योंकि कंपनी एग्जिस्ट करती है। लिक्विडेशन में क्या
बराबर।
होता है कि रिसीट एंड पेमेंट अकाउंट बनता है।
हम्म
लिक्विडेशन में भी अलग से दिया हुआ है कि क्या बुक्स मेंटेन करनी है। जब आप आईटीआर फॉर्म देखते हो ना, तो आईटीआर फॉर्म
हम्म
में कॉलम आता है कि क्या कंपनी लिक्विडेशन में चली गई है। अगर लिक्विडेशन में
हम्म।
चली गई तो रिसीट एंड पेमेंट अकाउंट खुल जाता है आईटीआर में।
ओके ओके
हम्म।
ओके ओके।
और सीआईआरपी में तो नॉर्मल अकाउंटिंग जैसे चलती है वो चलती रहती है। क्योंकि
तो
सीआईआरपी
वो
में
भी
तो
बैलेंस
ऐसा हो
बैलेंस।
सकता है ना कि नया बायर
हम्म।
आ जाए, तो कंपनी
बराबर।
डिसॉल्व तो होगी नहीं ना उस केस में।
हम्म।
तो कंपनी तो चलती रहेगी, सिर्फ मैनेजमेंट
तो
उसकी
ये
चेंज हो जाएगी।
तो ईयर एंड पे नॉर्मल बैलेंस शीट जैसे बनती थी वैसे ही
हाँ, नॉर्मल
बनेगी?
बैलेंस शीट बनती थी, सिर्फ उसको बोर्ड साइन नहीं करेगा, आईआरपी साइन
हम्म
कर देगा, कंपनी सेक्रेटरी साइन कर देगा।
बराबर।
हाँ,
राइट
यही है।
राइट। ओके। या
हाँ।
ओके।
और किसी का कोई सवाल हो तो?
I have one question.
यस प्लीज।
This, what is the tenure IRP can sustain? Because IRP at one point of time have to make the resolution. No?
Basically, once the committee is constituted, then one of the decisions the committee of creditors will take is whether to continue to avail the services of this IRP or to replace him. So this is first. This is one of the major decisions which is taken by the COC in the first meeting itself. So till the first meeting of the COC, IRP continues to stay in control. But in the first meeting itself, they may remove him or they may appoint him as RP. So instead of IRP, then he will become RP.
Okay.
And
There's no
any
timeline.
decision will be taken with 66% majority. So in the first meeting itself, IRP may be replaced and he may continue as RP. And in any subsequent meeting also, suppose 10 meetings of COC take place, after 10 meetings also they may decide that okay, let us replace him.
Mhm.
So any decision with 66% majority anytime by the COC.
There is no fixed tenure for IRP. Okay, like a 6 months, 9 months, nothing like that, right? Can
No.
be
Actually,
fixed within one.
IRP continues to stay till RP is appointed.
Okay, okay,
Because that seat cannot be left blank.
okay,
The seat of IRP cannot be left blank. So somebody has to be in place. So till the time RP is appointed, IRP continues to perform the role. And in the normally in the first meeting of the COC, decision to this effect is taken.
okay.
So in the first meeting itself, what they will do? They will decide whether to retain your services or to replace him. And they may decide regarding the cost also. Suppose the IRP has claimed a bill of 10 lakhs, but the COC may say we are willing to pay you only 5 lakhs. So then the IRP shall go to the adjudicating authority, and whatever adjudicating authority decides, that will be final.
Okay.
सर एक
Thanks.
छोटा कॉन्सेप्चुअल क्वेश्चन इसी रिलेटेड अभी
हाँ
जैसे हमने बोला कि ऑल फाइलिंग ऑल कंटिन्यूइंग द बिजनेस फाइलिंग ऑल रिटर्न्स IT all every responsibilities of IRP. Now suppose IRP gets replaced in the COC meeting on say 30th of the month, and now from first new RP has taken over. Then
Right.
for the last month period, filing all returns of the last month will be whose responsibility? IRP or RP? New RP?
New RP.
अच्छा,
Because whatever are the records and information available, that the old RP, the outgoing RP will, the outgoing IRP or RP will hand it over to the incoming IRP or RP.
बराबर.
हाँ.
वो तो वैसे
तो
भी उस
नए का
तारीख के बाद
रिस्पॉन्सिबिलिटी
तो
रहेगा. This responsibility has to be discharged from the date of filing only. भाई
ओके
मान
ओके.
लीजिए 30th मार्च को अब वो रिप्लेस हो गया, है ना.
हाँ
31st मार्च को नया आ गया एंड द रिटर्न हैज
बराबर
टू बी फाइल्ड से ऑन 7th ऑफ अप्रैल. तो 7th ऑफ अप्रैल को पुराने वाले को तो नहीं बुलाएंगे ना, नया ही फाइल करेगा.
बराबर.
हाँ. वो
राइट
तो ये
राइट.
जो जो इन्फॉर्मेशन उसके पास होगी वो उसको दे देगा. ये तो होता ही है.
बराबर. राइट. ओके ओके.
So now actually I'll be attending this World Federation of Accountants WUFA हो रहा है ना, तो I will not be available on 30th, 31st and 1st. तो next meeting will be on 2nd of February. That means Monday. तो next meeting हमारी Monday होगी. On Saturday there will be no meeting. So instead of Saturday we will be having a meeting on Monday and then on Tuesday. ठीक है जी.
ओके
Okay, sir.
सर.
So 2nd and 3rd February, we will be having the
Yes,
session.
yes, 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 yes.
Okay. Okay,
Yes.
sir.
हाँ,
Thank
thank
you.
Any
Thank
of
you.
you coming to WOFA?
No, sir.
Okay.
और मिस्टर राजन जी इज कमिंग.
अच्छा ठीक है. ओके.
ओके.